All right, now in an advisory opinion issued today, the Supreme Court held that while the President and governors cannot indefinitely delay action on bills, constitutional courts cannot impose rigid, judicially enforceable timelines for them to grant assent. The Apex Court also ruled out the concept of deemed assent if timelines are breached, stating that drawing timelines for constitutional functionaries like the governor and president would be anti-ethical to the doctrine of separation of powers. However, despite rejecting fixed timelines, the Apex Court maintained that governors and the president cannot sit over bills endlessly and must act within a reasonable time. The five-judge constitutional bench, headed by Chief Justice B.R. Gavai, unanimously held that it would be against the interest of federalism if the governor, without following due process under Article 200, is allowed to withhold bills. Article 200 deals with power given to governors to provide assent to bills passed by the Assembly. The court also said that if there is unexplained and prolonged inaction that frustrates the legislative process, courts can exercise a limited power of judicial review to direct the constitutional authority to make a decision in a time-bound manner. Without commenting on the bill's merits, the advisor's opinion came in response to a presidential reference made by President Draupadi Murmu under Article 143 of the Constitution. This followed an April 2025 Supreme Court judgment in the state of Tamil Nadu versus Governor of Tamil Nadu case, where a two-judge bench using Article 142 powers had prescribed specific timelines for presidential assent and had even granted deemed assent to 10 pending Tamil Nadu bills. I have my colleague Sambhav Sharma joining me with more details. Sambhav, what more can you add to this?
Well, the five-judge constitutional bench of the Supreme Court, headed by the Chief Justice of India, B.R. Gavai, has very clearly said that timeline cannot be fixed for governor and the president. And this is important in a way that the Supreme Court has now clearly said, and in a way changed the earlier judgment of the Supreme Court two-judge bench, where on April 8th, the top court has said that the 3-month deadline set a 3-month deadline for dealing with the bills placed for consideration for governors and president. And here, in a way, slightly overturned. The top court has slightly overturned this earlier ruling, by five-judge constitutional bench today by Chief Justice of India, B.R. Gavai, Justice Surikant, Justice Vikramnath, Justice T.S. Narasimha, and Justice A.S. Chandolkar. Five-judge Supreme Court bench has stated that it cannot impose timelines on president and governors, and also in the top court has said that the concept of quote-unquote deemed assent is alien to Indian Constitution. And we have the copy of the judgment. It's 101 pages, I beg your pardon, 111 pages of in a way, Supreme Court's opinion advisory on whether it can impose a timeline on the president and the state governors for acting on bills passed by state legislature. Here, the five-judge bench has unanimously said that the concept of deemed assent is alien to Indian Constitution, and said that the timelines cannot be imposed on president and governor to decide on pending bills. However, what is more important here is that the top court has said that the decision is to be taken in a reasonable time by the governors, and the governors cannot sit on bill endlessly, and if governors sit on bill endlessly, then limited judicial review in a way kicks in, is what is said by the five-judge constitution bench. It has clarified on many aspects. One of the major aspects is this, that limited judicial review can take place. In the case that if a government is sitting on a bill endlessly. However, no timeline can be fixed, or rather timeline can't be fixed for governor and the president. The top court has made it clear, a slight change from the earlier judgment where 3-month deadline was fixed by the top court while dealing with the bills. So here the five-judge Supreme Court bench has made these points very clear.
Thanks, Sambhav. Now, I also have Advocate Vineet Jindal, the advocate from the Supreme Court, joining me on the broadcast. Now, Mr. Jindal, how do you see this latest ruling by the Supreme Court?
A good judgment. I must say that now the Supreme Court has maintained both the things, the judicial review and the administrative powers by this judgment. It has been specifically stated that the court have a very limited interference while deciding such kind of extraordinary issues like governors situation. So now it has been specified by the Supreme Court by this judgment that governors cannot sit on any bill untimely, but court cannot give any kind of direction to specific directions to pass a bill on a specific time period. So definitely the Supreme Court judgment now maintaining the decency of the constitutional and the power of the government, and also taking care of the limited their limited resource and limited power to intervene with the administrative rules. So I think it is a good judgment, and the court has do their best and justified their limitations by deciding this kind of issues of Article 200, Article 221, constitutional right which has given to the governor. According to that, they have their own powers, so we cannot step upon their powers. But definitely, we are also here to safeguard the rights of the people, rights of the government. So definitely, it can be done in a different kind of manner, and especially stated that they have a limited power to enter into this kind of issues. So I must say this is a very good judgment, and the heaviness of how the judicial review can be made regarding this kind of prolonging bill. Now it has been clarified by the Supreme Court, and I think now the state who has been regularly objecting upon why the governors has been taking so much time and they are come to the court. Now it has been stopped, and I think that should be done in a appropriate manner.
All right. I also have Senior Advocate Mr. Vikas Pava joining me, Supreme Court, of course. Now, Mr. Pava, I want to begin by asking you, how do you see this new ruling by the Supreme Court, when which has held that while the President and governors cannot indefinitely delay action on bills, constitutional courts cannot impose rigid or judicially enforceable timelines for them to grant assent?
Well, I think it's a landmark judgment on this issue of interference with the work of the executives. Although the Supreme Court broadly has said that court should not interfere, but in the guidelines which are issued, the court has also allowed limited judicial review. Now, this limited judicial review is again basically on the timeline. The Honorable Supreme Court has said that wherever the courts feel that there is an inordinate delay, there are three words which have been given in the judgment: prolonged, unexplained, and indefinite delay. So if there's a prolonged delay, unexplained delay by the governor and the president, and it's indefinite, that there is no period of time which is mentioned, the high courts under Article 226 and the Supreme Court under Article 32 have the power to interfere to a limited extent, only to give a direction that within a reasonable period of time, the decision should be taken. I think that's a very good step in the sense that at least there is some control. Although there is no control, the judgment is very, very clear that the courts are not interfering in the business of the executives. But at the same time, if there is an inordinate delay, then there's a limited power of giving a direction. That itself, I feel, is a very landmark and very crucial, judgment which has been passed by the Honorable Supreme Court today.
Mr. Pava, there's this article 143, and the case arose after President Murmu exercised her rare power under Article 143(1) on May 13, which sought the court's opinion on whether fixed timelines could be imposed on governors. So what can you tell us about this article?
So in this article itself, this entire judgment has been passed. That is when the president feels that there is some clarity which is required on a judgment. The language of 143 itself says, and the heading is power of president to consult Supreme Court. So the reference had come from the president, a constitution bench was constituted, and the constitutional validity or the judgment which was passed by two judges where timeline was given was tested by the constitution bench, and then this judgment today has been delivered. So in a way, the constitution bench, although has not agreed with the timeline proposition, but at the same time, the constitution bench says that a limited power of judicial review is permissible under law, where a direction only for the purposes of expediting the decision on the bills can be given by the court. So therefore, a little bit of space has been created in that provision of law. But the Honorable President has rightly invoked the power under Article 143, which has resulted into passing of the judgment.